Good afternoon, everyone. I hope you can hear me. Thank you for joining us for the next in the series of Beale & Company's construction law updates. Following our webinar earlier this year, in which we gave an overview of the NEC3 engineering construction contract, and for any of you who missed this, it's available to be watched on YouTube. We'll be taking a closer look this time at two key features of the form: the compensation event provisions and the role of the project manager. We'll also deal with a number of topics which were raised by followers of our previous webinar. In the usual format, we'll start with some brief introductions. For those of you who don't know us, my name is Tom Pemberton, and I am joined by my partner, James Vernon. We are both members of the Construction, Engineering and Infrastructure team at Beale & Company. James and I are very pleased to have so many of you attending this webinar. We have just over 150 people joining us so far, which is fantastic. Before we start, I'd like to deal with the usual housekeeping items. The webinar is scheduled to last around 1 hour. During the webinar, you can submit questions to us in the appropriate box on the right-hand side of your screen. We'll try to deal with these during the webinar or at the end, if time permits. By way of a quick summary of what we aim to run through today, over the next hour, James and I will be looking at the key features of the compensation procedure and touch on the separate but related early warning provisions, and then go on to look at key aspects of the project manager's role. We will then briefly consider some of the topics raised in questions following our previous webinar, including on design liability, and in particular whether there is a gap in the liability of the contractor under the ECC and that of a design consultant appointed by the contractor under PSC, Professional Services Contract. Then we'll have a look at some risk in the work carried out by statutory undertakers, Option X15 partnering, the additional clause issued by NEC3 in November 2015 for early contractor involvement, and finally, contractor-initiated proposals to change the works information. So the specification prepared by Dr. Martin Barnes in 1987, prior to the publication of the first edition of NEC3, the new engineering contract, as it was then known, sets out a number of core principles which can be summarised as simplicity, clarity, and providing a stimulus to good management. And there on the screen you have a quote from Mr. Justice Ramsey in the case of WSB Cell Limited versus Dalkia Utility Services, which summarises well the underlying philosophy and the objective, which is to deal with issues during the process of a project by intensive management with a view to avoiding disputes at the end. So how far does NEC3 ECC bear out these core principles? Hopefully this webinar will demonstrate that what appears to be clear, simple and straightforward does not always result in procedures which are easy to manage or administer. Followers of this webinar will no doubt have their own opinions about this. So looking at early warning first of all, this fits into the general scheme of the NEC3, and according to the NEC3 guidance notes, the foresighted cooperative management of the interactions between the parties can reduce the risks inherent in construction and engineering work. And the early warning provisions exemplify the NEC3 philosophy that managing events is most successful if, before a solution is implemented, all parties contribute their expertise in a collaborative manner in order to minimise the impact on cost and time. This philosophy underlies the most important NEC3 procedures, including the procedure for notifying and assessing compensation events, which we'll come on to shortly. Now, the separate requirements to give early warning notices and compensation event notices must not be confused, although the former is often seen as a necessary preamble to the latter. James will speak in a bit more detail about the early warning procedure, including the calling of risk reduction meetings and the project manager's obligation to update the risk register. The point I would emphasise here is that the obligation to give early warning is not confined to notifying matters which may become compensation events, but may include, for example, any matter which could impair the performance of the works in use, which clearly isn't a compensation event. However, where an early warning matter does subsequently become a compensation event, if the project manager decides that the contractor did not give early warning of the event, which an experienced contractor could have given, the event is assessed as if the contractor had given early warning. So where early warning could have resulted in measures being taken to mitigate any delay or additional cost, this could obviously count against the contractor. So it's a real incentive for the contractor to comply with its early warning obligations. So core clauses 60 to 65 in the ECC form set out the provisions which I will be focusing on in the remainder of this section of the webinar. They're set out on this slide, including a description of the various compensation events and the obligation in respect of notification, assessment, provision of quotations, and finally implementation. James will look in more detail at some of the compensation event procedures in his consideration of the duties of the project manager. A key point to note is that compensation events potentially entitle the contractor to claim both an adjustment to its prices, i.e. the defined cost and the fee, and extension of time. This differentiates the NEC3 approach from other standard forms such as JCT and ICC, formerly ICE, where a claim for extension of time does not necessarily also give rise to a claim for additional payment. In this sense, NEC3 ECC may be regarded as relatively favourable to the contractor. So there are 19 core compensation events ranging from instruction by the project manager changing the works information in clause 60.11 to an event which neither party could prevent and is so unlikely that it would be unreasonable to expect an experienced contractor to have allowed for it in clause 60.119. Now clause 60.119 was introduced by the third edition of NEC ECC published in 2005. Almost invariably in our experience, it is deleted or heavily amended by the Option Z clauses, since it creates potential for the contractor to claim for events which would normally be seen as being its risk, such as, for example, the insolvency of a major supplier. If this has a significant and cost time impact, then there would then be likely to be a dispute as to whether that insolvency could have been prevented by the contractor, e.g. by accelerating payments to the supplier, and also whether it's so unlikely that it would be unreasonable to expect an experienced contractor to have allowed for it. Given that one of the NEC3 objectives was to increase certainty and to avoid scope for disputes by the use of words such as reasonable, since what is reasonable to the contractor may appear far from reasonable to the project manager, it's a little surprising that the NEC saw fit to introduce a compensation event in these terms into NEC3. Obviously, other forms provide for force majeure, and the NEC3 version of force majeure is an interesting variant on that. Now, main options B and D, the price contract with bill of quantities and the target contract with bill of quantities respectively, provide for the correction of inaccuracies and mistakes in the bill of quantities to be an additional compensation event. A number of the secondary option clauses also introduce additional compensation events if they're selected. For example, Option X2 permits claims to be made in relation to changes in the law, and Option Y UK2 provides that suspension of performance by the contractor in exercising its rights under the Construction Act is a compensation event. Furthermore, the contract data may identify additional employers' risks, the intention here being that the parties can agree the allocation of any project-specific risks which are not picked up in the standard provisions. The additional employers' risks are compensation events, or the occurrence of those risks are compensation events by virtue of clause 60.114. So a word about communications here. Pursuant to clause 13.7, the notification of compensation events must be communicated separately from other communications. This means that a compensation event notice must not be given in the same communication as an early warning notice or an application for payment, for example. It's a mistake which I think is quite a common mistake by contractors and others to confuse a compensation event notice, particularly with an early warning notice, and vice versa. Incidentally, under clause 13.1, each communication must be communicated in a form which can be read, copied and recorded. I have to say this is an uncharacteristically long-winded way of NEC3 saying that it must be in writing. Now, pursuant to clause 61.1, the project manager must notify compensation events where these arise from specified actions by the project manager or the supervisor, including the issue of instructions, certificates, changes to an earlier decision, or the correction of assumptions. The project manager must also give instructions to submit quotations in relation to these, these compensation events, unless the event arose from a fault of the contractor or a quotation has already been submitted. Now, pursuant to clause 21.2, the project manager may instruct the contractor to submit quotations for proposed compensation event. This instruction is not put into effect in terms of the compensation event itself unless and until the project manager gives a further instruction giving effect to it. So clause 61.3 is a very important provision. So where the project manager has not notified a compensation event, if the contractor does not notify the compensation event within 8 weeks of becoming aware of the event, he is not entitled to a change in the prices, the completion date, or a key date, unless it arises from specified actions by the project manager or the supervisor, including those which should have been notified as mentioned above, including the issue of instructions, certificates, changes to an earlier decision, or the correction of assumptions. An obvious question that arises in the context of this clause is who precisely needs to be aware of the event in the contractor's internal hierarchy. Case law going back to the Court of Appeal judgment in the H.L. Bolton engineering case in 1956 suggests that it is the senior management of the company and not merely, for example, its employees at site management level. However, the very recent case of Helmets Limited and Economy Devices Limited, reported only a couple of months ago, suggests that the knowledge of a contractor's junior employee of the occurrence of a compensation event will be deemed to fix the contractor, the whole company, with knowledge of the compensation event, even if, in breach of his duties to his employer, he fails to pass the information to his line manager, and so on up the company hierarchy to those with relevant authority and responsibility, such that the senior management of the company is not actually aware of the circumstances concerned. While Helmet concerned liability for fire breaking out in a factory and had nothing to do with NEC3 or claiming contractual entitlements, it seems to me that the principles are applicable to any circumstances where junior employees fail to report matters within their knowledge which affect the interests of the company and should therefore have been brought to the attention of senior management. Now, the lesson for contractors is clear. They must ensure they have effective reporting procedures which ensure that that events at site level which could have an impact on the wider business are drawn to the attention of senior management where necessary. Note that to be aware of an event includes an expectation that it may happen. Time may actually start to run before the event has occurred. Now, a further question which arises as to whether the time bar is effective to rule out entitlements based on breach or prevention by the employer itself, which is a compensation event according to clause 60.118. Now, some judgments in Commonwealth countries have suggested that an employer cannot rely on a time barring clause to disallow claims for extension of time based on the employer's own breach or act of prevention. However, in the case of Multiplex and Honeywell in 2007, the Technology and Construction Court in London took the view that the employer would be free to claim liquidated damages for delays caused by the employer's own acts if the contractor had failed to comply with a condition precedent notice provision in the contract. Mr. Justice Jackson, as he then was, considered that otherwise the contractor could deliberately ignore the contractual notice provisions in order to set time at large and effectively take away the employer's right to claim liquidated damages, or in NEC language, delay damages. The contractor would then be better off ignoring the notice requirements than complying with them. The courts considered that this situation would be unacceptable. There are provisions for the project manager to be deemed to accept that an event is a compensation event if he fails to respond to the contractor's notices, including a chaser notice, within the contract timescales. James will speak in some more detail about these provisions, but I would say that they are of limited assistance to the contractor, since a deemed acceptance can in fact be reviewed and revised by the adjudicator. Now, it's important to differentiate assumptions from forecasts in terms of assessment of compensation events. As regards assumptions, the project manager may state assumptions about the compensation event in his instruction to the contractor to submit quotations. So where something is too uncertain to take a final view about the impact of a compensation event, then the project manager may state an assumption which is to be made by the contractor, and the assessment of the event is then based on those assumptions. If any of the assumptions is later found to have been wrong, the project manager has to notify a correction, and this is a compensation event pursuant to clause 60.1.17. A correction of assumption may, of course, lead to an increased assessment of cost and delay, but it may also, or alternatively, result in a reduction of the prices if the effect of the compensation event is to reduce total defined cost. However, the completion date and the key dates cannot be brought forward in this situation. In addition to any assumptions stated by the project manager in his instruction, assessments must be based on assumption that the contractor reacted promptly and competently to the compensation event, that the defined cost is reasonably incurred, and that the accepted program can be changed. These particular assumptions do not fall to be corrected if they turn out to be wrong. Now, by contrast with the effect of a correction to an assumption stated by the project manager, the assessment of a compensation event is not revised if a forecast upon which it is based is shown by later recorded information to have been wrong. Although this could work against the contractor if the forecast did not fully allow for the effects of the compensation event, it could equally work in favour of the contractor if the agreed quotation or assessment included risk allowances for matters which, as it turns out, do not occur. Now, clause 63.6 is relevant here. This states that assessments must include risk allowances for cost and time for matters which have a significant chance of occurring and are at the contractor's risk under the contract. This underlines that the prospective or forward-looking basis of assessing compensation events almost inevitably means that one party or the other will end up ahead, and the other will therefore end up behind of actual costs and time impacts compared to a retrospective basis of evaluation. So in other words, a contractor could actually gain a benefit from a forward-looking evaluation because the risk events don't occur, or conversely, risk events do occur and they're more severe than they'd allowed for, in which case the contractor suffers a detriment. So a lot of contractors and employers like to have the greater certainty which is conferred by retrospective valuation. I have to say though, in the context of a typical infrastructure project, there should be some evening out of the outcomes in the context of multiple compensation events. Now, pursuant to clause 62.1, the project manager may instruct the contractor to submit alternative quotations after discussing with the contractor different ways of dealing with the compensation events which are practicable. And pursuant to clause 6.62.2, the contractor's quotations must include its assessment of the changes to the prices and any delays to the completion date and the key dates. Hence, if a quotation does not deal with all the relief sought and is accepted or treated as accepted by the project manager, the contractor will have lost his right to that part of the relief not dealt with by the quotation. Now, pursuant to clause 63.1, the changes to the prices are assessed as the effect of the compensation event upon the actual defined cost of the work already done, the forecast defined cost of the work not yet done, and the resulting fee. If the compensation event arises from a communication by the project manager or the supervisor, for example, the issue of an instruction, the date of the communication divides the work already done from the work not yet done. And in other cases, the date of notification of the compensation event, normally by the contractor, divides the work already done from the work not yet done. It's worth noting that options A, B and D allow the contractor and the project manager to agree to base the assessment of a compensation event on rates and lump sums rather than defined cost. And I've already talked about the prospective basis of assessment. Now, in terms of time and the extension to the completion date, pursuant to clause 63.3, a delay to the completion date is assessed as the length of time that due to the compensation event, planned completion is later than planned completion as shown on the accepted programme. This indicates that the ECC envisages that the contractor may plan to complete the works earlier than the contractual completion date, and hence the reference to planned completion. The consequence of this is that the contractor owns the float, which is effectively a contingency or additional contingency for delays which are at the contractor's risk. Now, pursuant to clause 62.6, the project manager is deemed to accept the contractor's quotation if he fails to respond within the required timescales. Although under options W1 and W2, the adjudicator may review and revise any inaction of the project manager, including a deemed acceptance of the contractor's quotation. Now, James will look in more detail at the project manager's obligations in relation to responding to quotations and, where relevant, making his own assessment. So I'll just have a quick word about implementation under clause 65.1, which states that compensation events are implemented when the project manager notifies his acceptance of the contractor's quotation, or when the project manager notifies the contractor of his own assessment, or when a contractor's quotation is treated as having been accepted by the project manager. And once implemented, the compensation event is finished with, so there's no going back, except possibly by recourse to adjudication, and subsequently the tribunal if necessary. So I'll just conclude this section of the webinar by drawing a few conclusions in terms of challenges for the project manager and the contractor. And this quick overview, we've seen that some compensation events are governed by a complex set of rules which impose a heavier administrative burden than other comparable standard forms of engineering construction contract. If quotations or project manager assessments are not agreed, disputes often concern whether an adjudicator can look at actual outcomes in terms of delay and cost. Accordingly, in order to forestall disputes, parties often seek to reduce the administrative burden by agreeing traditional ICE or ICE approaches to valuing compensation events. For example, that the final valuation of compensation events is to be agreed on a retrospective basis after completion, that compensation events should be bundled in monthly updates rather than dealt with in separate notices which could deluge the project manager bearing in mind his responsibilities to respond separately to each compensation event notice and quotation, and agreeing a threshold below which the compensation event regime does not apply. This would presumably be on the basis that there is deemed to be allowance in the prices and the programme for small compensation events up to a certain value. Now, it's important to ensure that any agreed departure from the ECC compensation event provisions is reflected in agreed Z clauses and amendments to the core clauses where relevant. The case of Mears and Shoreline, which I'll summarise briefly in a moment, indicates that otherwise one of the parties would probably be able to insist on a strict adherence to the ECC conditions. I'll finally, in this final slide in this section, have a quick look at the relevance of the partnering ethos to the administration compensation events. Now, the effective management of the compensation event process, it depends on collaboration and transparency between the project manager and the contractor, and the manner prescribed by clause 10.1, which requires that the contractor, the employer, the project manager and the supervisor act as stated in this contract and in a spirit of trust and mutual cooperation. Now, I should say that a party which fails to comply with the letter of the compensation event procedures cannot rely on clause 10.1 in order to avoid the consequences. This lesson can be drawn from the recent case of Mears and Shoreline Housing Partnership, which concerned whether the contractor was entitled to recover payments on a different basis from a contract pricing mechanism which had been found to be inappropriate. Now, initially the employer agreed to proceed on an alternative pricing basis, but it then realised it was not achieving the cost savings it had anticipated and sought to recover the overpayments it had made by reference to the contractual pricing mechanism. Now, Mr. Justice Aiken had decided the case in favour of the contractor based on estoppel principles. But importantly, he stated he was not satisfied that the obligation to act in a spirit of trust and cooperation, or even in a partnering way, would prevent either party from relying on any express terms of the contract. And it's worth noting that the obligation in clause 10.1 does include an obligation to act as stated in the contract, in other words, to comply with the procedures, as well as in a spirit of mutual trust and cooperation. Finally, it's worth reflecting on the fact that the ECC form provides for potentially different consequences of the contractor and the project manager, respectively, failing to give notices or to take actions within the NEC3 ECC. As I've alluded to, there's dispute resolution options, W2 for where the Construction Act applies, and W1 for where it does not. Both provide that the adjudicator may review and revise any action or inaction of the project manager or supervisor related to the dispute and alter a quotation which has been treated as having been accepted. I have to say the contractor does not have a corresponding get out of jail free card. I'll now hand over to James, who will take you through the key provisions of the ECC form relating to the duties of the project manager.
Thank you, Tom. As set out on this slide, this part of the webinar is going to look at the role of the project manager generally and in relation to risk management and compensation events. And this is all integral to their contract administration role. The key players under an NEC3 ECC contract includes as participants the project manager. As a participant, the project manager has an important role. This reflects that the ECC is more of a management tool to be used continually through the life of a project. The collaborative nature of the NEC3 requires the input of all participants, but it is the active engagement of the project manager that can ensure the successful delivery of a project using this form of contract. Although project managers administer the contract, their role goes beyond that. Championing the philosophies of the NEC3 is a central part of their role, and this goes beyond acting solely as an agent of the employer. Those philosophies include the spirit of mutual trust and cooperation that is vital to the NE3's ethos, as Tom previously mentioned relating to clause 10.1. And collaborative working is not just a buzzword. It is of paramount importance, and the project manager must facilitate this in a proactive manner. In this regard, the project manager does have to be impartial and balance the interests of the contractor and employer. This is evident by the role they play on risk management, which I will come on to. The role of the project manager is not one that can be taken on lightly. It may be more complex and onerous than compared to other standard form contracts. To be able to carry out this role, the project manager must fully understand not only its duties, but how the other participants' roles impact on the successful operation of the contract. This requires knowledge of the type of work being carried out, including design issues that can arise on such jobs, how to deal with risk evaluation, management, and programming. Without such knowledge, the project manager's ability to comply with his or her duties and to operate the contract properly will be greatly undermined. This is particularly so when dealing with early warnings and the risk register. Fortunately, one let-off for the project manager, if I can call it that, is they have no responsibility for inspecting the work quality. This is done by the supervisor. This allows the project manager, where those roles are divided between two different entities, to concentrate on administering the contract. Before I look at specifics of the role as set down by the ECC, it is important to note that the employer has no contractual right to challenge the actions and decisions of the project manager. This goes hand in hand with the need for the project manager to have sufficient authority to make decisions necessary under the contract. As I will summarise on the next slide, the project manager is responsible for many actions and cannot be hindered by the need to seek confirmation or clarification of its role from the employer, or indeed the employer's view on a particular issue before making a decision. In this respect, the project manager should, as early as possible, sit down with the employer to understand how it proposes to manage its responsibilities on the project, so that in the event that the input from the employer is needed, they can be raised to the right person who understands the need for a quick response. In this way, the NEC3 ECC does differ from the JCT, for example. It goes without saying that for the issues that I will set out, and as Tom has previously raised, resourcing the role of project manager is vital. And in terms of the resourcing and management of the project manager role, we consider it's normal that the project manager will be appointed using the professional service contract. This is best practice, although as I say, the project manager will also need to be fully aware of its obligations under the ECC. Set out in this slide is a list of the main actions and duties of the project manager, and I don't propose to go through each one. These are here for a checklist. Some of these duties are relatively straightforward or will not occur very often. The specific clauses referred to need to be reviewed by the project manager, as not only do they state the tasks on them, but also provide some guidance to the project manager as to how to carry out those tasks. As you will see, one of the fundamental jobs of the project manager is to issue instructions and to monitor progress. The project manager is the best place to do this as part of the management process of the NEC3. Drilling down into the specific duties of the project manager, we have identified three key areas for further discussion. Firstly, risk management. Secondly, contract administration. And thirdly, communication, including in respect of compensation events. Dealing with risk management first. Proactive risk management is a central feature of NEC3 ECC. Without it, the collaborative nature of the contract could potentially fall apart, leading to the parties to become entrenched in their position. The need for proactivity is reflected in the general risk management role of the project manager. Risks should be anticipated and planned for, so that their impact can be minimized, if not eliminated, so as any delay and/or disruption and impact on costs is reduced. As part of this role, the project manager has a leading role in identifying risk at the outset of the project and evaluating the probability and potential outcome of that risk. This is why the employer must ensure the competency of the project manager and that he or she is engaged from a very early stage. It is also why in the contract data part 1, the parties can set out the initial risks to be included in the first draft of the risk register. Thereafter, the project manager must ensure that there are regular risk reviews by all involved in the project, so that the impact of potential previously identified risks can be monitored and that new risks can be dealt with quickly and effectively. In terms of the project manager's specific risk management role, the key clause in the ECC is number 16 regarding early warnings. As set out in the guidance notes of the contract, the purpose of clause 16 is to make binding the obligation to warn as soon as possible of anything that may affect the cost, time for completion, or time for completion of a key date, or the quality of the works. As discussed by Tom, the failure by the contractor to give an early warning potentially reduces the payment due to him for a related compensation event under clause 63.5. An early warning is given either by the project manager or the contractor by notifying each other. It is in the interest of the project manager to make such notification so that the parties have sufficient time to consider the issue and manage the risk so this is mitigated as far as possible. So what should be notified as an early warning? As before, it is any matter which could increase the price, cause delay to completion or meeting a key date, or impair the quality of the works. The use of the word any means that the potential for matters to be captured by this requirement is very broad. Once an early warning is notified, it is the responsibility of the project manager to enter that matter into the risk register. This is a key role for the project manager to ensure that each risk is identified and effectively managed. In this regard, the risk register is defined as a register of the risks which are listed in the contract data and the risk notified as an early warning matter. Therefore, this is a vital tool for the control of risk and must be established from the very outset. The risk register must contain a description of the risk and a description of the actions which are to be taken to avoid or reduce the risk, including who owns the actions. However, this does not mean that the project manager, in making such entries, should attempt to apportion legal responsibility or liability for any risk on a particular party. It is simply a management tool to manage and mitigate those risks. By way of clause 16.2, at any time the project manager or the contractor decides it's relevant, they can call a risk reduction meeting. The purpose of these meetings is to discuss matters which have been referred as early warnings and so are on the risk register, and to consider whether there are any potential issues relating to future work. These meetings are an essential way in which the project manager can control and manage risk. As a matter of good practice, and to ensure that the collaborative nature of the reporting and managing of risk is promoted, the first risk reduction meeting should take place at an early stage of the project, and future meetings should be set down in advance so the parties know they will take place every fortnight or every month as applicable. Clause 16.3 of the ECC sets out the aims of the risk reduction meeting. This includes discussion of solutions and identifying the most appropriate party responsible for actioning. Following the meeting, it is the project manager's responsibility to update the risk register, including the identification of those actions agreed and the timescale to take those actions. Further, if it is necessary, the project manager instructs any change to the works information necessary to carry out any decided course of action to reduce risk. The project manager has a crucial contract administration role, and some of these points are set out on this slide. Again, this is part of the project manager being the central hub to ensure the parties work collaboratively to achieve the project's objectives. As I've said before, a project manager should be well versed in the requirements of the ECC and his or her duties thereunder. This is particularly so as some obligations on the project manager have short time periods for action and significant ramifications if those time limits are not met. These time limits are necessary to ensure the machinery of the ECC does not break down. Some specific examples of instructions that a project manager is required to give is set out on this slide. As Tom has mentioned, under clause 61.2 and 61.4, the project manager can instruct the contractor to provide quotations for compensation events, and this is something I will go on to discuss in a moment. It should be noted that these instructions issued by the project manager will not always give rise to a compensation event. This is the same for instructions under a JCT contract, which are not always considered a variation or relevant event. The project manager also plays an important role in payment, aside from dealing with compensation events. And so the project manager must have QS skills or is able to call on assistance from someone who has. This is similar to the role and necessary skill set for a contract administrator under the JCT standard form, for example. In terms of specifics, under clause 50.1, the project manager assesses the amount due to the contractor at each assessment date. This includes consideration under clause 50.4 of any application for payment from the contractor. In making an assessment, the project manager will give the contractor details of how the amount due has been assessed. And the project manager also has the opportunity to correct in that assessment any previous incorrect assessments. Thereafter, once the amount due is assessed, the project manager certifies the amount due to the contractor. Under clause 51.1, this is to be done within 1 week for each assessment date. Finally, for this part of the webinar, under clause 30.2, the project manager decides the date of completion and must certify completion within 1 week of it. This is important as it raises the importance of close working between the project manager and the supervisor, as it is the supervisor whose duties include overseeing tests and inspections carried out by the contractor, and therefore it is the supervisor that will be able to give input as to whether completion has been reached. Turning now to communication and leading on to compensation events. Under clause 13.1, all instructions and notifications are to be in writing. Oral comments and agreements, for example, from the risk reduction meeting, are not effective until recorded. Further, the contract data specifies the period for replies. Under clause 13.3, the project manager must comply with this period. If the project manager does not, then a compensation event will arise under clause 60.16. Also in clause 13, it is stated that where the project manager does not accept a communication from the contractor, the reasons for such non-acceptance are to be stated in the project manager's reply. Clause 13.5 provides for the project manager and the contractor to be able to extend the period for a reply if it is agreed before the reply is due. This extension is then notified by the project manager to the contractor in writing. The obligations on the project manager for communication is demonstrated best by the project manager's role in the management and assessment of compensation events. Tom has taken you through some of the key mechanisms, so I will focus on the project manager's role. As a starting point, it is the project manager who can trigger a compensation event. For example, if the project manager gives an instruction changing the works information, this is a compensation event under clause 60.11. Further, it can be a compensation event if the project manager gives an instruction to stop or not start any work or to change a key date in accordance with clause 60.14. If the project manager changes a decision previously communicated to the contractor, this is a compensation event under clause 60.18. Under clause 61.1, any compensation events which arise from a project manager's instruction or changing an earlier decision, it is the project manager who notifies the contractor of the compensation event at the time such instruction or change is communicated. At this time, the project manager also instructs the contractor to provide a quotation unless the underlying matter arises from a fault of the contractor or from quotations already submitted. In this situation, the project manager must not wait for the contractor to notify such events. It is the project manager's responsibility, and failure to do so may give rise to late claims by the contractor that would otherwise be time barred. It is such late claims which the NEC3 ECC has been designed to avoid. Even where it's not for the project manager to notify a compensation event, a project manager should exercise such entitlement as soon as possible. If the project manager does not but should have done, then under clause 61.3, the contractor is effectively allowed more than the 8 weeks to notify, starting from the period he first became aware of the event. It is then for the project manager under clause 61.4 to decide if an event entitles the contractor to a change in price or time for completion, or a change to a key date, and this is to be done within 1 week of the contractor's notification. If the project manager does not do so, and fails to then reply within a further 2 weeks of notification from the contractor of such a failure, then the event is treated as a compensation event and an instruction to the contractor to submit quotations. As such, by a project manager's inaction and failing to adequately resource a project to be able to respond within the timeframes, a matter could be taken to be a compensation event, even though ordinarily it would have been rejected. Such inaction is to the detriment of the employer. By clause 61.5, the project manager does have the power to decide that the contractor did not give an early warning, and this can factor into whether that would then become a compensation event. The project manager then has obligations with regard to the quotations for compensation events. These include that after discussion with the contractor, the project manager may instruct alternative quotations. On receipt of the quotation, the project manager is to reply within 2 weeks. The reply is either an instruction to submit a revised quotation, an acceptance of a quotation, or a notification that the project manager will be making their own assessment. Of course, this final step should only be taken if the project manager considers that they have the relevant skills and expertise to do so. If the project manager instructs a revised quotations, he or she must explain the reasons for doing so. Importantly, under clause 62.6, if the project manager does not reply to a quotation within 2 weeks, the contractor may notify the project manager of this. If there is still no response within a further 2 weeks, then the quotation is deemed to be accepted. And this is a significant risk on the project manager and identifies the need for effective management. The project manager can have an obligation to make its own assessments of compensation events under clause 64. Such an obligation arises if the contractor has not submitted a quotation, or if the contracting manager decides that the contractor has not assessed the compensation event correctly in a quotation and a revised quotation is not instructed, or if the contractor has failed to submit a program or revisions to a program that are required with a quotation. The project manager is to then notify the contractor of his or her assessment of a compensation event and give details within the same time limit allowed for the contractor's submission, with the time starting to run from when it was apparent that such a quotation by the project manager is necessary. If the project manager does not assess a quotation within the time allowed, then, as before, if the contractor notifies the project manager of this, the quotation must be assessed within a further 2 weeks, otherwise the notification from the contractor is treated as acceptance of the quotation therein. So those points go to show the importance the project manager plays in compensation events and the needs to keep an active dialogue with the contractor throughout. In this regard, there is still very little case law in NEC3, but one important case is Costain v. Betchell, which is on this slide, and this dealt with whether the project manager could act in the interests of the employer when undertaking their certification role, or whether they had a duty to act impartially. In this case, it was held that the project manager has a duty to act impartially, and as such, its position is similar to the JCT and can be summarised as follows. The duty to act impartially covers the position when the project manager has to exercise discretion between the employer and the contractor. However, when the project manager issues instructions and notices, these are done on behalf of the employer, and so the project manager can, in these circumstances, act in the interests of the employer. To bring this section to a close, on this slide are some practical tips as we see them from the role of project managers. Project managers should be seen as a driver more than an administrator. They should play an active role, and they should be looking to deal with matters as they arise on the project and not waiting to the end of a project to resolve. The project manager must ensure that they understand and are aware of the main contract mechanisms for early warning notices, compensation events, and anything that requires a response within a certain period of time. There are templates and precedent forms that allow the project manager to have a mechanism by which swift responses can be given and recorded in writing. This should, if possible, be agreed with the contractor so that all understand the format of the notices that will be issued on the project. The project manager should keep track of its instructions and actions by way of a register that is circulated to all parties so everyone can see how the project is progressing and also who owns any actions if there are matters which may fall to be risks under the risk register. Contentious quotations should be regularly reviewed to ensure that the work being done is being done in an effective way and without an excessive potential increase in the costs. And as before, it's the project manager who should lead the process and champion the NEC philosophy. This is part of the spirit of mutual trust and cooperation. That brings to the end what Tom and I wanted to discuss today on compensation events and the project manager role. As Tom mentioned earlier, we were asked some specific questions following our webinar on the NEC3 earlier this year, and the 5 key ones are set out on this slide. So if I take the first question, the simple answer is yes. As we see it, there is a gap in design liability between the ECC and the PSC. Under the ECC, a contractor's liability for its design is strict, i.e. it must be carried out in accordance with the work's information. This is an obvious example of such an obligation giving rise to the requirement for a design to be fit for purpose. If it is not, the contractor will be liable to either rectify the works installed to a defective design under clause 43.1 or to compensate the employer for their costs of rectifying, together with any other losses incurred by the employer, for example, loss of use. Such a claim would not be covered by the contractor's professional indemnity insurance. Cover is typically not extended to fitness for purpose obligations. Therefore, contractors must use option clause X15 in order to bring its design liability in line with that of designers under the PSC, i.e. the contractor has to produce the design with reasonable skill and care. In this regard, there are a few things of interest to note with X15. Firstly, it is for the contractor to provide that its design was carried out with reasonable skill and care. This is a reversal from the norm whereby the employer would have to show that on the balance of probabilities, the design carried out by the contractor was not done with reasonable skill and care. Secondly, with X15, if the defect exists, but the contractor's design was carried out with reasonable skill and care, the contractor is still required to correct the work. However, that correction is a compensation event. The next question I would like to look at is regarding early contractor involvement. This is a new matter that's come up from November last year, and it does differ between the ECC and the way early contractor involvement is dealt with by the JCT, for example. Under the JCT, early contractor involvement is done using a separate contract, whereas under the ECC, it is a new additional clause to supplement the core clauses. Under the ECC, early contractor involvement has been split into 2 stages, imaginatively titled Stage 1 and Stage 2. Typically, what happens in each stage is defined in the works information, but in general terms, Stage 1 is where the contractor leads the development of the design in consultation with the employer and others, or the contractor is consulted on the development of the design as it progresses. Thereafter, Stage 2 is where the detailed design is completed and then constructed. In the ECC, it is a requirement that a contractual notice is issued by the project manager on behalf of the employer to allow the contractor to proceed from Stage 1 to Stage 2. Such a contractual notice is issued in response to the contractor submitting a proposal to move to stage 2. This is a requirement. On receipt of such a notice from the contractor, the project manager can raise objections to the proposal, and it may request revised submissions. It should be noted that there is no guarantee that the employer will proceed with the stage 1 contractor for stage 2, especially if the price cannot be agreed. This introduces one of the main criticisms of the ECC clause, which is that the stage 1 contractor has a contract with the employer, but if the employer chooses to proceed with another contractor, there is no express provision terminating the first contractor's contract. This could lead to potential arguments that the employer has terminated the first contractor's contract. Under clause 93.4, this may entitle the contractor to be paid their direct fee percentage, and so the employer would have to pay more to the contractor than it would anticipate. In addition, it should be noted that the intellectual property for design information produced during stage 1 will remain with the employer. This is in contrast to the JCT, where unless otherwise agreed, copyright remains vested in the contractor. And I will now hand you back to Tom, who will deal with the remaining questions.
Thanks, James. So I'm going to look at the remaining questions on that slide. The first of them is which party bears the risk under the ECC of delay or other defective performance by statutory undertakers? This is largely a question of scope. If the statutory undertaker's work is within the scope of work set out in this works information, then in principle the contractor takes responsibility for any defective work and or delay by the statutory undertakers. In effect, the statutory undertakers are, in this scenario, acting as the contractor's subcontractors. However, if, as we would expect, the statutory undertakers are not appointed as subcontractors by the contractor, they would fall in the category of others with a capital O. In this case, if they do not work within the time shown on the accepted programme, this would be a compensation event pursuant to clause 60.15, and of course the contractor has the entitlements we have been talking about in the earlier part of the webinar. Now, the provisions of the works information dealing with work by statutory undertakers should be carefully drafted and reviewed to ensure consistency with this approach. Now, we also asked for our view of option X12, the partnering option. Now, I'd be very interested to hear from anyone who has been involved in an ECC contract which incorporates X12, since in our experience this is unusual. Now, there's insufficient time to go into the ramifications of this option, but option X12 is intended to add an additional level of partnering to the NEC mix. It's tacked on to the various contracts between the employer on the one hand and the contractor and the various key consultants and key specialists on the other, rather than creating a multi-party contract such as PPC 2000. Accordingly, option X12 doesn't give all the various parties enforceable legal rights against each other, but the NEC have suggested the final sanction against any partner who fails to act as stated in the partnering option is for the partner who employed them, which is obviously normally the employer, not to invite them to partner again. Now, the core provision in X12 is the formation of a core group which has a general supervisory role in respect of timetabling and sharing of information. As a general point, an employer who wants to create a multi-party partnering team is probably more likely to select PPC 2000, for example. I suspect that employers are often reluctant to incorporate X12 into its NEC contracts because an instruction by the core group which changes the way the parties to the partnering option are required to work together would itself be a compensation event. Turning now to the final topic on the slide, which is contractor initiated proposals to change the works information. Now, NEC3, the ECC, does not provide for the contractor to initiate changes to the works information, but it's nothing to prevent the contractor from volunteering suggested changes to the project manager. And of course, if the project manager considers that they would be beneficial to the employer and or to the project, he could then issue an instruction. But if the employer wants to incentivize the contractor to initiate proposals which could result in cost savings by way of value engineering, for example, or improved performance, then an appropriate Option Z clause could be agreed. This may, for example, include provision for any savings or other financial benefits to the employer to be shared in pre-agreed proportion. The JCT Major Projects form includes drafting in relation to cost savings and value improvements, which could be referred to as a precedent for this purpose. Now, people have raised some interesting additional questions in the course of this webinar, and since we've really used up our hour, we will follow up on these after the webinar. So thanks everyone for joining the webinar, and we hope that you will join us in our next construction law update webinar, details of which will be announced shortly. Now feel free to contact James or myself in the meantime if you have any questions arising from this webinar or experiences to share. With those thoughts, we'll sign off and conclude this webinar. Thank you very much.